Okay, we are now live and on the record for Monday morning civil docket, April 25th, 2022. Mr. Eddie Trevino, what do you have?
Good morning, Judge.
Good morning.
I have a cause number CL 21-2686I, Jesus Alva versus Santos Transports. We were just retained on Friday. We filed our notice of appearance.
Okay, that's number 10 on the court's docket. Okay.
So we're going to be asking for some additional time so I can review the documents and file the.
Was Mr. Lopez going to get on, or are you making the announcement for the case for both of you?
No, I have not talked to Mr. Lopez, so I don't know where he stands or where he's at.
Okay, so how much time are you requesting?
Judge, well, we need 30 days should be enough time. I think there's no discovery has been made in this case, and I don't know where we stand as far as Mr. Lopez is. So we're going to need some time.
Okay. I'm going to go ahead and give you a little bit more time because I don't know, since you just got on. So it'll be June 22nd.
Okay.
At 9:30.
That'll work, Judge.
I'm sorry. Go ahead, Ms. Rivera.
Yes, Judge. Mr. Lopez did notify the court that he would probably be using our public access computer due to the fact that he did have court in person, but he's not made it yet. Just for the record.
Okay. I'm sorry. It's not going. I have to give you a Monday date because Mondays are the Zoom days. So it's not going to be the 22nd. It'll be the 20th.
Okay. That'll work.
Judge,
Okay.
I apologize. It'll be the 27th.
The 27th?
Yes, ma'am.
Okay. It'll be the 27th.
Got it.
All right. And that'll be at 9:30 if you can let Mr. Lopez know.
Thank you, Judge. We will.
Okay. Yes.
Thank you.
Okay, Mr. McLaughlin?
Yes, Your Honor. I have 7 cases that should go very quickly.
Okay. Go ahead.
The first one is number 4.
CL1.
I believe. Go ahead.
CL164601-I Midland Funding versus Michael Rodriguez.
Yes, I believe that we presented a default judgment earlier, but perhaps there was not an order on file, and I'm asking that it be retained, and I will make sure that an order is sent to the court.
Okay. Go ahead, and that is what happened. So go ahead and get that order in as soon as possible, and then we'll get that set for you.
Thank you. The second one is number 5 on the docket.
CL190423-I Portfolio Recovery versus Adriana Garcia.
We've filed a default judgment, and we need to file an order requesting a hearing date.
Okay, go ahead and get that submitted, and we'll get that set.
Okay. Next one is number 6 on the docket.
CL190469-I Cascade Capital versus Jose Martinez.
Yes, and we need to request a trial date.
Okay, Mr. Martinez, did he file an answer?
Yes, I believe he did.
Okay, Jose A. Martinez. Jose A. Martinez. Okay, so you're requesting a bench trial date?
Yes, Your Honor.
Okay, Ms. Rivera, what do we have available, ma'am?
1 second, Judge. Let me.
Sure.
Judge, would this be on Zoom or via or in person, Your Honor?
Since it'll be probably a no-show, it can be on Zoom.
Okay, Judge, we have June the 6th or the 27th, either day, but the order setting hearing would have to be filed, Your Honor.
Correct. Okay, Mr. McLaughlin, June 6th or June 27th?
I would ask for June 6th.
Okay, go ahead and get an order setting hearing on file with the bench trial date of June 6th at 11 a.m.
Yes, Your Honor. The next one is number 9 on your docket.
Okay. That's CL 210026-I, Bank of America versus Joanna Gonzalez.
Yes, and I believe that they filed an answer, and we would request a bench trial. If we could do it on June 6th at 11, I would greatly appreciate it.
That is fine. Just go ahead and make sure that you have those submitted so that we can get those sent out.
Okay. Number 18 on your docket.
CL 196530-I, TD Auto Finance versus Carlos Quintanilla.
A motion for default judgment was filed, and I believe that we need to request a hearing date on that.
Okay, so you don't have an order setting hearing on that?
I don't think that there is one.
Set for this morning, Your Honor.
Oh, that's why, I mean, if I have it set for a
Oh.
motion for default judgment, it would have to be, you would have had to have submitted one.
Okay. Then,
Are you
I would,
prepared to move forward with it?
yes, Your Honor, I am.
Okay, Carlos Quintanilla, Carlos Quintanilla, Carlos Quintanilla. Okay, go ahead, you may proceed.
In this case, we believe that Mr. Quintanilla had purchased a vehicle with a motor vehicle retail installment contract with TD Auto Finance. He purchased it in January of 2018. He subsequently ceased payments. The car was repossessed and sold at auction with a deficiency of $34,893.15. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice of the business records, the non-military declaration, certificate of last known address, and issue judgment for the plaintiff.
The court is taking judicial notice of all the documents in the court's file, specifically the service that was returned, and no answer is on file as to this to date. Therefore, the court is granting the relief as requested and put on the record. Is there an order on file? Do you see that, Ms. Rivera?
Yes, ma'am, there is.
Okay, I'll go ahead and ask for that order to be forwarded to my queue, and we'll get that signed off for you.
Thank you, Your Honor. Number 20 on the docket.
CL 23486-I, Crown Asset Management versus Laura Perez.
In this case, we're seeking a default judgment on this one, and I believe that an order setting hearing for today had been filed with the court.
Yes. The court is taking judicial notice of all the documents in the court's file. Laura Perez, Laura Perez, Laura Perez. Okay, the name being called out 3 times and no response. You may proceed.
In this case, we believe that the defendant had opened up a Walmart credit card in November of 2016, making her last payment in June of 2018. The account was closed and charged off and has a current balance of $1,860.34. We're seeking that amount in damages plus costs to the court, and would ask the court to take notice of the supporting documents and issue judgment for the plaintiff.
Okay. The court is further noting that service has been on file for the required amount of time. No answer has been filed as to this date. Therefore, the court is granting the relief as requested on the record. And I'll ask for that order to be forwarded to my queue.
The last one I have is number 29 on your docket.
Give me the case number.
CL 193806.
Okay, that's number 27 on my docket. One Main Financial versus Miguel Esparza.
Your Honor, Jack Skaggs for Miguel Esparza.
Okay. And
So-
what is the status?
We just received documents that the plaintiff had produced a couple of weeks ago, and I'm analyzing those, and we would request another 30 to 60 days so we can see if we can try to work something out on that.
Okay, anything else, Mr. McLaughlin?
No, Your Honor. If I could just get the opposing counsel's name again.
My name is Jack Skaggs.
Okay. I have no objection to 30 to 60 days, Your Honor.
Okay. That's fine, then we'll return on that one on June 27th at 9:30.
Thank you, Your Honor. That's all I have. May I be excused?
Before I release you, I need to check something on number, Mr. Skaggs, do you have anything further?
No, ma'am, I don't.
Okay, then we'll see you back here on June 27th, sir.
Okay, thank you, Your Honor.
Thank you.
May I be
I'm gonna,
excused?
yes, sir. I'm gonna check something on number 20 because my staff is saying that, I don't know how it's said if there's no motion, because there's a motion for default judgment that it was set for today. However, now they're telling me that there's no motion or order. I'm not sure. Can you please clarify, Ms. Rivera, or?
Yes, Judge, in reviewing the case, there is no motion and there's no order. However, this wasn't a bunch that an order setting hearing for whatever reason was pending, but in reviewing the case, there is no motion or order.
Hold on.
To be clear, Your Honor, no motion for default judgment or no motion for setting hearing?
Well, the court
Yeah.
only requires an order setting hearing, so the motion would not be required, but there's no motion for default judgment or the order granting. There was, however, an order setting the hearing for that particular motion.
Oh, okay. So there was an order setting hearing for the motion for default judgment, but there's not an order granting.
Or the motion, Judge.
Okay. I think you all got ahead of yourselves on that case, Mr. McLaughlin, and went ahead and filed an order setting hearing for a default judgment, but inadvertently didn't file the motion for default judgment.
I will make sure it's on file with the court today and file a new request for a order setting hearing.
Yes, go ahead and do that, and then we'll take it up. So for right now, I'm going to set aside the granting of that motion for default judgment, and then we will take it up at the appropriate time then, okay?
Okay, thank you, Your Honor. That's all I have.
Okay, thank you. Go ahead and set a tickler, Ms. Ivana, for 2 weeks in case it doesn't get filed, so we can set it on the drop docket.
Absolutely, Judge.
All right. Okay, Mr. Villalobos.
Good morning, Your Honor.
Good morning, sir. What do you have?
Ma'am, I've got F-1515-20-9, Oneida Hernandez versus Ruben Flores.
Okay, do you know what number that is on the court
No,
docket?
Judge, I'm sorry. I don't know. Don't know
Number
what number
13,
it
Your
is.
Honor.
Okay, that's number 13 on the court's docket in the matter of the marriage of Oneida Hernandez and Ruben Hernandez Flores.
Yes. Your Honor, that case, Mrs. Hernandez started it pro se. She's retained me, I believe it was last month, to try to finalize it for her. I'm in the process of finding the gentleman so I can serve him. That's been the problem that she was having. But I've made an appearance on it. I've asked the court for a little bit of time so I can serve him. And I anticipate it's going to be a default judgment, Judge. But there's a little bit of time.
Okay, well, how much time are you requesting?
Can we have 60 days, Judge, so that I can serve him, make sure I get him served, and by the time we come, we can have a final hearing. We'll get it set. But next time you give us a setting, we can come in and close it out.
Okay, June 27th at 9:30.
Thank you so much, Your Honor.
Okay, let's try to get it done on that date, please.
Okay, we'll be set for final hearing June 27th, 9:30.
Yes.
Thank you, ma'am. We will close it out that day.
Okay, thank you.
You have a great day, ma'am.
Likewise. Okay, Mr. Arce?
Good morning, Judge. I'm here on docket number 17, CL 22-0981, Ricardo Arce versus Ruben Arce.
Okay,
And the defendant has appealed the JP court ruling on March 16th, so we are here today for that. And I'm the plaintiff on that one.
okay, was Mr. Palacios going to be showing up?
I have no clue, Your Honor.
Okay, let me go ahead and see if someone can contact Mr. Palacios so that I can go ahead and hear you.
Judge,
Thank
he
you,
might
Judge.
be appearing in person, Your Honor, to the public
Okay.
access.
Okay. So he's there at the courthouse, so he may be appearing at the public access computer that we have in our office.
Okay, Judge.
Okay, so just be on standby.
Okay, thank you.
Thank you. All right, Ms. Rodriguez, what do you have?
Good morning, Judge. I'm here on number 24,
CL 21-2871-I, Evangelina Cantu versus Hector Rodriguez et al.
Danielle Rodriguez for the plaintiff, Evangelina Cantu.
Good morning, Your Honor. This is Robert Cantu on behalf of defendant Hector Rodriguez.
Okay, and is this your motion, Ms. Rodriguez?
Yes, Judge, this case has two defendants. So our motion for substitute service is for the other defendant, Jesse Sanchez. We have, despite our due diligence, haven't been able to serve defendant Jesse Sanchez. I would ask that the court take judicial notice of the affidavit of our process server, which has been filed with the court.
Okay, the court is taking judicial notice of the documents in the court's file, specifically the affidavit from the civil process server. Go on.
So we're asking that the court authorize the plaintiff to serve defendant Jesse Sanchez by leaving a true copy of the citation and plaintiff's original petition with anyone more than 16 years of age at the address 4410 West Jenica Circle, San Juan, Texas 78589, or by posting a copy of the citation and petition on the gated door of that address.
Okay. Mr. Cantu, you only represent Mr. Rodriguez, correct?
Correct, Your Honor.
Okay, so you don't have an opinion on this motion. Okay.
I do not.
Okay, so I don't see in the affidavit though. Are they sure, is he sure that he lives there? Like, will he be able to receive service? Will he know about this? Does he live there? Go ahead.
Okay, so we had initially a different address for the defendant. The address on the police report, he ended up selling that property. So this new address was a property that I found on the deed of the sale. So he should be at that address.
Okay, gotcha. All right. So the court is taking judicial notice of the documents in the court's file and is granting your motion for substituted service. And I'll go ahead and ask for the order that was filed on April 1st to be forwarded to my queue. Okay, anything else?
Nothing further from me, Judge.
Okay, anything else, Mr. Cantu?
No, Your Honor, that's it.
Okay, y'all have a great day.
Thank you,
Thank you.
too.
Thank you. Mr. Garza, Attorney Frank Garza, what do you have, sir?
Good morning, Judge. Number 25, also a motion for substitute service on CL 22-1057-I. And on this matter, Judge, if the court could take judicial notice of our motion and affidavit of our civil process server as well.
Okay.
And on
The
this,
court-
yes.
The court is taking judicial notice of the documents in the court's file, specifically the affidavit by the civil process server and which was filed on April the 7th. Go ahead.
Yes, Judge, on this matter, our process server has, as the affidavit states out, has attempted to serve the defendant at 708 Briarwood Court in Mission, Texas. Three visits. After the third visit, he returned later in the evening after 8 o'clock at night. Someone was there at the house. They turned off the lights, refused to answer the door. That is the address.
Hold
And,
on.
hold on, Judge.
I muted the person. Okay, go on.
Yes, Judge, I apologize. Okay, so on this
It's
matter,
fine.
Judge, it is based on our information in the affidavit that the defendant does reside there. He does have a Ring camera, so that's part of the reason no one's answered the door, we suspect. We got the address right off the accident report, and it's a very recent accident, Judge, as well. So we'd request for order granting substitute service as listed in our proposed order, that it could be left on the door of anyone over the age of 16, putting in the mail slot, slipping it under the front door, attaching to the front door, or attaching in the gate in front of the house, Judge.
Okay. The court is granting your motion for substituted service, and I'll ask for the order that was filed on April 7th to be forwarded to my queue, and I'll sign off on it.
Thank you, Judge. Appreciate it. That's all I have before the court, Judge.
Okay, thank you. You have a good day.
Take care. Thank you.
Thank you. Mr. Ballesteros, Attorney Alejandro Ballesteros, what do you have, sir?
Yes, good morning, Judge. We have number 16 on your docket. It's an ad litem.
CL 192353-I, Esther, ESTHER Garza Espinosa, ESPINOSA versus Jeanette, JEANETTE Hart.
Ashley Rincon for the plaintiff, Esther Espinosa. I'm trying to find her on the grid. I don't know if you can call out her name. She also speaks only in Spanish, though. We would be requesting a court interpreter.
Okay, Ms. Castañeda, can you please see if Esther Garza Espinosa is on?
Esther Garza Espinosa, por favor, se anuncia.
Aquí estoy.
I'm here.
Okay. Is anybody else needing to be sworn in?
I don't think so, Your Honor, but I would like to make an announcement. I'm here for the defense. Selena Lopez Leon from the Law Office of Ralph Rodriguez.
Okay, thank you. All right, so all attorneys are on and the witness is on. Ms. Castañeda, please ask her to raise her right hand.
Señora Garza Espinosa, por favor, levanta su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí, señora.
Yes, ma'am.
Have her lower her hand.
¿Puede bajar su mano?
Okay, go ahead, Ms. Rincon. Just go slow so that Ms. Castañeda can interpret for you.
Right. Good morning, Ms. Espinosa. I just have a few questions for you. Your
Ms. Espinosa, tengo unas preguntas para usted.
Gracias.
All right. Your son, Roman Rodriguez, he is, in fact, your son, correct?
Su hijo Román Rodríguez, ¿ese es su hijo, correcto?
Sí.
Yes.
And your son has recovered from the injuries sustained in this accident, and I'm not aware of any continuing medical problems, correct?
Su hijo se ha recuperado de las, los daños que tuvo de este accidente y no tiene ahorita futuros daños, ¿correcto?
Sí, señora.
Yes, ma'am.
And do you understand that the settlement funds will be deposited with the registry of the court in an interest-bearing account for the sole benefit of your son, correct?
Y usted está avisada que los fondos para este accidente se van a poner en el registro de la corte, ¿correcto?
Correcto.
Correct.
And you understand that the amount of $3,000 and with $76.46 will be deposited into the registry of the court, correct?
Ms. Rincon, can you repeat the amount again, please?
Yes, sorry. $3,076.46.
Y está usted al pendiente que la cantidad es $3,076.46 es lo que se va a poner en el registro de la corte, ¿correcto?
Sí, así es.
Yes, that's right.
And do you believe that is in the best interest of your son to settle this case in accordance with the agreement, and by settling this case that you are giving up your right to a jury trial?
¿Y está usted de acuerdo que este es en el mejor interés para su hijo y está usted avisando que no va a ser un juicio por jurado, correcto?
Correcto. Sí,
Correct.
señora.
Yes, ma'am.
And you understand by accepting the settlement, any existing injury to your son or any that may arise in the future, you will no longer be able to recover from the defendant or their insurer, correct?
Y usted está de acuerdo que al aceptar este acuerdo, ya no va a poder venir si tiene más, costos médicos, no puede venir contra la aseguranza otra vez, ¿correcto?
Sí, sí, señora.
Yes, yes, ma'am.
And you are asking the honorable judge of this court to approve the settlement?
¿Y usted le está pidiendo a esta corte que apruebe este acuerdo?
Sí.
Yes.
I pass the witness, Your Honor.
Okay, Ms. Lopez Leon, do you have any questions of the witness?
Just a couple, Your Honor, if I may proceed.
Go ahead.
Good morning, ma'am. My name is Selena Leon with the Law Office of Ralph Rodriguez, and we represent the defendant in this lawsuit.
Okay, mi nombre es Selena López León y nosotros representamos al acusado en este caso.
Buenos días.
Good morning.
Good morning. Ma'am, are you asking the court to adopt the settlement agreement today because it is in the best interest of your son?
Usted le está pidiendo esta corte que acepte este acuerdo porque es en el mejor interés para su hijo.
Claro que sí. Sí.
Yes, ma'am.
And although there's an amount going into the registry, you understand the total settlement amount is $10,000, correct?
Y a usted sabe que aunque la cantidad que va a ir para el registro de la corte, la cantidad era $10,000, ¿correcto?
Sí, señora.
Yes, ma'am.
But there are monies to be paid to the medical provider as well as your attorney. So the total amount left is what we went over. You understand that? That's going to go into the registry?
Pero hay cantidades que se van a pagar para costos médicos y para su abogado, o la cantidad que le quedó es lo que va a entrar al registro, ¿correcto?
Sí.
Yes.
And that this is the total amount you will ever receive either now or in the future from defendant Hart or her insured. You understand that?
Y esta cantidad es lo que va a recibir ahora y en el futuro. ¿Sí entiende usted eso?
Sí, lo entiendo.
Yes, I understand.
And you are voluntarily asking the court to adopt the agreement, correct?
Y usted voluntariamente le está pidiendo a la corte que acepte este acuerdo, ¿correcto?
Sí.
Yes.
Thank you. I'll pass, Your Honor.
Okay, Mr. Ballesteros, do you have any questions of the witness?
Just briefly, Your Honor, if I may proceed.
Go ahead.
Good morning, Ms. Espinosa.
Buenos días, Espinosa.
Buenos días.
Good morning.
We went over Roman's settlement back in July and August of 2020. Is that correct?
Sí.
Nosotros revisamos este acuerdo va en julio, agosto del 2020, ¿correcto?
Sí, así es.
Yes, that's right.
We also went over Roman's, the injuries that Roman sustained in the accident of 2018. Is that correct?
También repasamos sobre las lesiones que Román tuvo en el 2018, ¿correcto?
Sí.
Yes.
And based on us going over the file and the medical records, Roman has no future injuries. Is that correct?
Y repasando el caso, Román no tiene médicos no tiene problemas médicos para el futuro, ¿correcto?
Correcto.
Correct.
And we also discussed that the amount that Roman was going to be receiving was a total that the De La Garza law firm reduced their fees from 40% to 20%.
Y también estamos de acuerdo que la oficina de La Garza redujo sus costos de 40% a 20%, ¿correcto?
Sí.
Yes.
And then out of the $10,000 settlement, Roman was going to receive $3,076.46.
Y de del total de $10,000, Román iba a recibir $3,000.76.46, ¿correcto?
Sí.
Yes.
And that would be deposited into the registry of the court until Roman turned 18 years old.
Y ese se va a depositar en el registro de la corte hasta que Román cumpla 18, ¿correcto?
Sí.
Yes.
And you understand that by agreeing to this settlement that you can't come back and sue the insurance company or the defendant in this case.
Y usted está de acuerdo que cuando a recibir esto ya no puede venir para atrás y demandar otra vez a la compañía del aseguro, ¿correcto?
Correcto.
Correct.
Thank you, Ms. Espinosa. I have no further questions, Judge, and it is my opinion that this settlement is in the best interest of the minor and would request the court to approve it.
And have your fees already been agreed to?
Yes, Judge, I did confer with defense counsel on this over the weekend, and the fees have been agreed to.
Okay. Ms. Dinquan, how old is the child?
I can't remember. I was trying to look that up right now, Your Honor.
She's
I'm
like
sorry.
13 or 14, Judge. Date of birth is 2009, so I think 13.
Okay. Ms. Castañeda, ask her how old her son is.
Ms. Espinosa, ¿cuántos años tiene su hijo?
Oh, we lost her. Okay. I was just curious because it's such a small amount to be going into the registry of the court, but I guess it can earn some interest. Well, the court is going to grant the agreement as testified to on the record. Have y'all circulated the order for signature?
I will work on that in our office, Your Honor. We'll get that sent out today or tomorrow if that appeases the court. There was one other minor hiccup. We had sent inadvertently, our office sent the checks to Mr. De La Garza's office for the total amount, and they were cashed. So the money that needs to be put in the registry, I guess we'll have to work that out with Mr. De La Garza's office. It's going to have to come from his.
Okay.
Judge, and if the court is inclined to, because of the small amount, to release the funds to the mother, it is my opinion that she is a good custodian and guardian of the minor. He was 11 when I met with him. He's probably around 13 now. And I know that they could apply him to some of his extracurricular and schooling needs if the court's inclined to do that as well.
I agree with you, Mr. Ballesteros. I mean, I think that I'm going to go ahead in light of that order that be released directly to the mother. I mean, I know school year's just about to end, and then I'm sure, I mean, by the time we know it, she's going to have the expenses of school coming in. And so to me, that is a very small amount that doesn't need to be going through the registry of the court. So since the order has not been circulated, you still have time to go ahead and draft that, put that in there, and just make sure that all of you sign off on it. And perhaps it'll be easier for them just to go ahead and cut the check directly to her.
Yes, Your Honor.
Okay. If you can explain that, Ms. Dinquan, because your client got out for some reason, and then she hasn't tried to come back in.
Yes, Your Honor. I'll speak with her. If I can just have the option, if she chooses to have it with the court, with the registry of the court, would that still be an option? I'm sure she would rather have it for her son right now, but just that she has that option and I can relay that to her.
That's fine. I'll be surprised if that's what she picks, but yes, that's fine.
Okay. Thank you, Your Honor.
All right. Anything else?
Nothing further, Your Honor. May we be excused?
Yes. Y'all have a blessed day.
Thank you.
You as well, Your Honor.
All right. Okay, Mr. Osuna, what do you have, sir?
Good morning, Your Honor. Jose Osuna for the record. We have number 28 on the court's docket. It's F 2415-19-9. That case is styled in the matter of the marriage of Julissa de Leon Sanchez and Jose Monreal. I do not see either of the litigants online, Your Honor. If my memory serves me, I don't think they've appeared for the last maybe 2 or 3 settings.
Yes.
This was a case, Your Honor, in which the young lady was struggling with meeting the requirements of service. We brought that to the court's attention. The court observed that had been the case, and she has not corrected that, Your Honor. So I suspect she may have abandoned the divorce.
Okay. Well, what I'm going to do is I'm just going to set this for the drop docket, and I'll let you know. We'll give you notice as to that. I thank you so much for your help on this, and we'll see what ends up happening.
Yes, Your Honor. I appreciate it. Thank you.
Okay. Anything else?
Nothing further, Your Honor.
All right. Thank you. You have a good day.
You too.
All right. Mr. Moreno, what do you have, sir?
Good morning, Your Honor. Number 29 on the court's docket.
Okay. CL 151106-I, Lord and Gonzalez versus Ignacio Perez et al.
Yes, ma'am. This matter has been postponed several times to give one of the defendants, Elsa Perez, an opportunity to hire counsel. And she's here on the line. Also, the other defendant is on the line, Mr. Rick Godinez, may be on another hearing, but the matter only relates to Elsa Pettis, Your Honor.
Okay, Ms. Bettis, have you been able to secure, so you go by Bettis, not Perkle?
Correct. Yes, ma'am.
Okay. And were you able to secure counsel, ma'am?
I have not, Judge. As of Friday, I was under the impression the other defendant is my father, Mr. Perez. And I believe that he understood that Mr. Godinez was retained to represent us both because we're both defendants. After speaking to Mr. Godinez's office on Friday, I was made aware that I am not represented by Mr. Godinez, as I believed and my father believed as well. So at this time, I have not retained counsel. Again, it was a misunderstanding, just something that wasn't very clear. I live in California. I've lived in California for a while, so I just found out about this case recently. I wasn't served like in person, you know. And so there's a lot of documents that pertain to the case that I have in storage in Texas. Because of COVID travel, I haven't been able to make it that way. I plan on making it to Texas this summer. I'm a teacher, and so I'm pretty tied up, you know, during the school year. But the bottom line is I have not retained counsel. And so I'll just take your guidance from here.
Okay, so the documents that you state that pertain to this case, I'm assuming those are documents, Mr. Moreno, that will be pertinent to discovery?
Your Honor, I've provided all the documents to both parties that I have.
Okay.
So she may have other documents that I'm not aware of.
Okay, when is it that you would be coming?
In probably the middle of June is when I would be making it to Texas. So like I said, I just need a little bit of time if the court allows. I know this has been going on for a long time. Like I said, I was just made aware of it. And because of logistics, it has been a little bit more difficult, and financially, honestly, it's been a little bit more difficult for me to.
So I understand that. So do you, and what's the premise of this case, Mr. Moreno? Can you just tell me?
Yes, this relates to debt that arises from a lease that Mr. Pettis signed and Ms. Pettis guaranteed.
Yeah.
Okay.
I was a co-signer, Judge.
Okay.
This was 10 years ago, so it's going a while back. And
all right. So, but the lease is on what? On plots? On what?
It was a commercial property, Your Honor.
Oh, okay. Since it was Lord and Gonzalez, I thought of the funeral home for some reason.
No. I'm sorry. No, it's.
So I thought it had something to do with that. Okay. So it's a lease on a commercial property.
Yes.
Okay. And so there was a default on the lease?
Yes, Your Honor. And then they had a settlement agreement afterwards because my client was required to do a lot of renovations to the property to meet their needs, and also even advance some funds for things like deposits for utilities and other things. So, and then they had a discussion and came to a settlement with Mr. Pettis.
Okay.
And that's the amount we're seeking, Your Honor, the settlement amount.
Which is what?
It's about $27,000.
Okay.
And Judge, if I may, just the agreement was made by Mr. Pettis. Like I said, I was just a co-signer on the actual lease. So I'm on that agreement. I was not a part of that agreement. That was made separately and outside of my knowledge.
No, and I understand that. The thing is that's a defense. And so you are going to need to have an attorney do that for you and argue it. And then there are pleadings, which are, you know, they call anything you file with the court is called a pleading. So there are pleadings that you can file that will bring that to my attention, and there can be a hearing as to whether or not you should be included in this or not. Okay. But before we can get to any of all that, and before we can talk about what can we do, you need either counsel or just decide that you're going to represent yourself. But I can't imagine if you're claiming that there are documents that you have that will pertain to this case, I would assume that whatever happens, the attorneys will want to see those documents so that everyone can make an informed decision. Okay. Do you think that you will be here before June 27th? Okay, why don't I tell you this? You need to be here before June 27th because we will have a status hearing on June 27th, and we're going to talk about whether you need to have come down, gotten those documents.
Okay.
You need to have either retained counsel or move forward on your own. You need to copy all those documents. You need to give Mr. Moreno a copy, and you need to give Mr. Godinez a copy.
Yes, sir.
And of course, retain a copy for yourself. Because you never know if that's going to make this case turn or what.
Yes, ma'am.
But you need to make sure that you get that. So you need to come down. When does your school year end?
On the June the 1st, I should be free.
Okay. So, I mean, I'm sorry that you're going to have to make the trek down here because it also does, I mean, I'm sure it's pricey. You know, it's not like gas is cheap nor airfare, but you know, it's going to be something that you're going to need to do. So go ahead and do that. And we'll come back on June the 27th at 9:30. Okay.
I understand. Thank you, Judge.
And that will be a Zoom meeting, Your Honor?
As of right now, that'll be Zoom at June 27th at 9:30.
Okay.
Okay.
I'll
So,
submit a proposed order, Your Honor.
all right, is Mr. Bettis English speaking or Spanish speaking?
He speaks English, Your Honor. He's
Oh,
on the public
English.
access.
Yes.
I think he's trying over there.
Yeah. Ms. Rivera, can you have Mr. Damian unmute him, please?
I'm sorry. Here, Judge.
Oh, there you go. Okay. So, Mr. Bettis, we're gonna come back on June the 27th, okay? Because your daughter's going to come down and get those papers for you all.
Yes, that'll be fine. We appreciate your honor. That's one thing that you will be very kind and do it for me, but I didn't get. Remember that I told you that if we didn't get the 2 original papers, the trial wasn't gonna be fair. And you asked Mr. Moreno to send me copies of the papers, and he did send it, but not the right original papers. Without those 2 original papers, this trial is going to be very difficult because those 2 original papers are what it will tell you the truth, you know. So see to have them get you the original lease agreement and the original the other paper. And there's a lot of difference between the original papers and what Mr. Moreno wrote on the lawsuit. So if you please ask him for those 2 original papers. I did ask Mr. Moreno, he was very kind, and he said, look, Mr. Perez, this is all I got, this is all that they gave me, but they didn't give him the original papers. You get these 2 original papers and you get this case resolved in 10 minutes.
Okay.
All
right, so-
I've given all the papers that my client says he has, and if there's other papers, if he wants to give me a date, that would help me find papers.
Okay, so let's let Ms. Bettis get the documents that she's going to come down to get. And then we'll have an exchange of those documents as an informal discovery. And Mr. Bettis, Mr. Godinez will be responsible for your part, and Mr. Moreno will continue to contact him. Okay?
Yes,
all right. So we'll see
Thank you.
everybody back here on June the 27th at 9:30. If you can please let Mr. Godinez know.
I will, Your Honor.
Okay, thank you. Y'all have a great day.
You too.
God bless you. Don't work too hard.
Okay, God bless you too.
Thank you.
Take care. All right, Mr. Hernandez, what do you have, sir?
Good morning, Judge. I have 2 default judgments, docket 21 and 22.
All right, CL 21-1749-I, Lax Valley Stores versus Juan Jose Ramos.
Yes,
Juan
Judge.
Jose Ramos, Juan Jose Ramos, Juan Jose Ramos. Go ahead, Mr. Hernandez.
Sure, Judge. If you could just take judicial notice of the entire file, Judge.
The court is taking judicial notice of the entire file. You may proceed.
Sure, Judge. Just for the record, lawsuit in this case was filed on May 4th, 2021, Judge. The defendant was served via subservice on February 9th, 2022. The return was filed on February 11th, 2022, Judge. Answer being due on March 7th, 2022. There being no answer, this case is ripe for a default judgment. As part of the record, we do have our damages affidavit from a representative of Lax Valley Stores. We have a attorney fees affidavit from my office, Judge. We have the certificate of last known address, and we have the service members affidavit, Judge. At this time, Lax Valley Stores is asking for a final default judgment against Juan Jose Ramos for the total amount of $6,927.31, Judge. There should be a proposed final default judgment in the court's queue ready for signature.
Okay. So the court does see that citation was properly issued, that he was served properly. The return of service has been on file for the required amount of time, and also sees your affidavits as stated on the record. The court is granting the relief as requested by the plaintiff on the record. No answer has been on file, and everything has been on for the required amount of time. And I'll go ahead and ask that to be forwarded to my queue that was filed on April 22nd.
Yes, Judge.
Okay, your next case is CL 21-2204-I, Lax Valley Stores versus Virginia Analy, A-N-A-L-Y Garcia, Virginia Garcia, Virginia Garcia. Go ahead.
Sure, Judge. Just if you could take judicial notice of the entire documents in the court's file.
The court is taking judicial notice of all the documents in the court's file.
Sure, Judge. Just for the record, this lawsuit was filed on June 16th, 2021. The defendant was served via subservice on February 10th, 2022. The return was filed on February 11th, 2022, Judge. Answer was due in this case on March 7th, 2022. There being no answer, this case is ripe for a default judgment, Judge. As part of the record, you have our damages affidavit from a representative of Lax Valley Stores. You have a attorney fees affidavit from my office. You have the certificate of last known address and the service members affidavit, Judge. All documents are on the court's file. This case is ripe for default judgment. We're asking for a default judgment against Virginia A. Garcia. And the total amount of the judgment is $5,372.72, Judge.
Okay. I see that the return of service has been on file for the required amount of time. No answer has been filed by the defendant to date. Therefore, the court is granting the relief as requested by the plaintiff on the record. And I'll ask for the order filed on April 22nd to be forwarded to my queue.
Perfect, Judge. That is all. Can I be excused, Judge?
You certainly may. Have a great day.
Likewise, Judge. Be safe.
Thank you. Mr. Arce?
Good morning, Judge. I was just checking back in. We had not heard from Mr. Palacios, and it's already been about an hour, and I don't want to waste any more of the court's time.
Okay, so Mr. Palacios had called in and said that he was released from court and was on his way back to his office,
Okay.
and that he would be logging in. He hasn't. I don't know if anybody wants to reach out, but
Yes, Judge, this is in JP court as well, Your Honor. So I'm just trying to, I have work and I'm missing work because of this, Your Honor.
okay. Yes, and I'm here doing the same. So
Yes, Your
giving the time to your case. So I can't force him to get on. If for some reason he doesn't get on by the time we finish the docket, well, then the relief will be granted, right? So we'll see what happens. Okay. All right, Mr. Nowak, what do you have?
Yes, Your Honor, I'm here on a motion for default judgment for docket number 23.
Okay, CL 21-2436-I, Olifant, OLIPHANT Financial versus Jorge, Jorge Miranda. Jorge Miranda. Go ahead. What is your announcement, Counselor?
Yes, Your Honor, this case is ripe for a default judgment. I'd ask the court to take judicial notice of the court's file. We have, this case was filed on June 8th, 2021. The defendant was served by 106 service on November 16th, 2021. The defendant did not file a response. The citation has been on file for more than 10 days. This originally relates to a web bank loan. A motion for default judgment has been filed with the appropriate certificate of last known address, declaration of non-military status, an affidavit from my office as to attorney's fees, and a business records affidavit showing the loan documents and the payment history and proof of assignment of the loan. So a proposed order is on file. We are asking for judgment as requested.
Okay, the court is taking judicial notice of all the documents in the court's file, specifically that service was returned served and that no answer has been filed to date. And the documents have been on file for the required amount of time. Therefore, the court is granting the relief as requested by the plaintiff and is asking for the order that was filed on February 24th, 2022 to be forwarded to my queue for signature.
Thank you, Your Honor. May I be excused?
You certainly may, sir.
Have a good day.
Thank you. Okay, Mr. Is that Fernandez, Rolando Fernandez?
Yes, Your Honor, it's Rolando Fernandez, space de space Lara.
Oh, okay, so you're here on a name change, correct?
Correct.
Okay, let me pull that up for you.
I think it's doc 26, if I'm correct.
It certainly is. Okay, so you're asking for your name to be changed to be all one, Fernandez de Lara all together, correct?
Altogether, yes, no spaces, no capital letters, just the F for Fernandez de Lara.
Okay, got it. The only issue that I see here, Mr. Fernandez de Lara, is that you're still missing your fingerprints.
I submitted them in. They were
Okay.
submitted with the
No, but I don't have them on file here in the court. Did
Oh.
you get the criminal history?
Well, I got all this. They gave. I submitted this to the court. I don't know. That's just
Okay, hold on.
the filing in.
Let me see. So you attached it as an exhibit?
Yes, because I mean, I went to the police station, got the
Okay.
fingerprints, and then went to your office and.
Yes, so you attached your fingerprint card to
Correct.
there, but that's not how you do it.
Oh.
So your fingerprint card needs to be sent to the to Austin. Because they need to give me a criminal history report to verify that that you're not trying to evade any charges or anything like that. So then once you send it to Austin, Austin's going to send you a criminal history report. And then when you get that criminal history report, you're going to file that with the clerk where you went to file everything else.
Mhm.
And then once that's on file, then I can look at your petition for name change. So you would have to file that with Austin first. When you receive it, the criminal history report, you're going to bring that to the clerk, and you're also going to bring an order resetting hearing. So it's the same paper that you did to set the hearing, but you're going to call it order resetting.
Resetting.
Yes. And then we'll go ahead and set you again.
Okay. Oh, perfect. That's
Okay. So I'm going to go ahead and give you some time.
Okay.
So I'm going to put you down for a status hearing on June the 27th at 9:30. If you have everything done by that date, we'll go ahead and take care of you on that date. If not, you need to give me an update as to where we are on your report, okay?
It is June 27? At what
At
time?
9:30.
9:30.
Yes, sir.
Okay. That's
All right.
it.
Okay, you have a great day.
Thank you. You too, Jennifer.
Okay, you take care. Okay, So, Mr. Arce and Mr. Palacios, I'm gonna recall your case. That's CL 220981-I, Ricardo E. Arce versus Ruben Arce. Announcements?
Ricardo Arce for the plaintiff, Your Honor.
Good morning, Judge Sunny Palacios, for the defendant, Ruben Arce.
Okay, and so, what do we have today, gentlemen?
Judge, this is a case, an appeal from an FED case that landed in precinct 4, place 1 of that matter. I did file a continuance in that hearing. I was in a federal hearing. However, the judge denied the continuance, asking that I leave the federal court and show up to his justice court. That's not the way it works.
Who was the judge on that?
Precinct 4-1.
I don't know who that is. I don't know which one it is. That's one. I don't
Charlie
know which Judge Espinosa. Okay.
Judge Charlie Espinosa.
Okay.
So, Judge, that's why we ended up appealing this case. It was defaulted back to Mr. Ricardo Arce. However, there are some matters on this FED and the way they happen. We're asking that the court hold this on their docket, allow me, Mr. Arce, maybe about 2 weeks to talk about this case and see if there's something that can be worked out. And if not, then we can have a hearing at that point, Judge.
Okay, so Mr. Arce, are you representing yourself in this matter?
Yes, Judge, I'm an attorney as well.
Oh, okay. So you're Ricardo Esteban?
Yes.
Okay, so but you go by Steve, right?
Yes, Judge. And if I may, at the JP court hearing, the reasoning for Mr. Palacios' motion for continuance was that his daughter was in the hospital. So that's what the judge had told me then.
Oh, I'm sorry, Judge. I'm sorry. Yes. As a matter of fact, I'm sorry. This one, Judge. My daughter was having her eye surgery up in Austin, if I'm not mistaken. Now it was March 16th or somewhere around there when she had her. As the court is aware, most judges are aware, my daughter lost one eye when she was 12, and we've been trying to do everything to save her remaining eye. She had her surgery on the 16th. We filed continuances on pretty much everything that day.
Okay, so Mr. Arce, do you want to know? I mean, do you welcome the opportunity to have a conversation with Mr. Palacios?
Judge, I've tried to reach out to his office multiple times. I have email correspondence, phone logs of this. To be honest, I'd rather just proceed just because it's already been over 2 months since I filed the notice to vacate. And it seems like this process has just been a delay of the court's time, and I don't want to waste any more of the court's time.
Judge, and we understand that this is a family issue, Judge. This is a house that started off as mom's, which was transferred, and there's some testimony that's going to have to come up before this court. We're hoping to do it before Judge Espinosa's court. However, that wasn't able to do so. It was transferred to Mr. Arce's father, then transferred down to Mr. Ricardo Arce, who's on screen. And so the things got...
Let me ask you this. Okay, who's Ruben Arce? Who's Ruben Arce to you, Mr. Arce?
Yes, he is my uncle, and he's been living with my grandma since 2008. She passed away on February 4th, and his tenancy there was just supposed to last up until her passing.
Okay.
There's no lease agreement. I tried to talk to him. He wasn't willing to compromise with me. So I just served him a notice to vacate on February 14th, Your Honor.
Okay, and you're the rightful owner of that house?
Yes, I was given a gift deed on March 17th, 2021, Your Honor.
Okay, I get it now.
And that's what it is, Judge. It's a family.
But other than that, in just taking the law as it is, have you had a conversation with Mr. Palacios with your client?
I have spoke with him, Judge. I've had asked the brothers to sit down with each other, see if there's any way to lease or rent the property, because right now it's a zero rent, so there is no income being lost or gained or anything like that.
Yes, but I think probably what Mr. Arce is looking at is that the potential income that could be coming in if he just rents it to somebody else. And we cannot force anybody to lease a house or anything to anyone just because he wants to stay there because he's been there for, whatever, 14 years.
And that's the issue, Judge. That's the main issue on this, the transfers, how they were transferred, where they're transferred, the purpose of the transfers.
Well, but I
And-
don't see anything on the documents that have been submitted by the JP court that may take into question about the transfer. This is about, the only thing I see in the documents of the JP court is the notice to vacate and the fact that he didn't vacate. So, and I do understand, I know, I'm getting the gist of all of this now, but okay, so let me tell you all, my contested cases are in person. I'm not going to deny you for putting on some testimony, but we're going to have a conversation before we have that little hearing in person, okay? So we're going to have this hearing in person. Ms. Rivera, can you give me the earliest Wednesday that we have at 2 o'clock?
May the 11th, Your Honor.
Okay, we're going to get together on May the 11th at 2 o'clock there at the courthouse. You need to have your witnesses. We're going to go forward with this on May the 11th at 2 o'clock. Okay.
That'll be perfect, Judge.
And so we'll be there. I'm hearing my cases in County Court 4.
Yes, Your Honor.
Okay. So if there's anybody that you're going to need to come in, make sure that you get them subpoenaed for that day on May the 11th at 2 p.m.
Judge, and if
We'll
I
do so, Judge.
can I just double check and verify what exactly the testimony is going to be, since every deed has been valid and there was no challenge of anything. And I just feel this is a further waste of the court's time, since I've been trying to contact Mr. Palacios. We've been having multiple hearings. He's been trying to continue cases. I mean, Ruben's been living there rent-free for a long time now. Utilities are stacking up. He already canceled the phone bill. My father is taking the phone bill, last phone bill, to pay for that. So I'm just confused on why we're going to keep continuing with this, Your Honor.
Well, let me make it clear, because I said you all are coming back on May the 11th at 2 p.m. Okay, so we'll get it settled on that day. But Mr. Palacios, I think you need to prepare your client. Okay, so
I will do so, Judge.
all right, and make sure that he understands. I cannot force Mr. Arce to rent this house to him. And like I said, in the documents that were submitted to me by the JP's court, I didn't see anything challenging any of the deeds, and I'm not going to allow any new evidence to come in. So whatever it is that, I can't allow any new evidence to come in. So whatever's on there, whatever's going to be testified to, or whatever it's going to be, because it was part of the record already. So nothing new is going to come in or anything like that. Now let me, Mr. Arce, are you local or are you out of town?
No, I live here in San Antonio, Your Honor.
Okay. Well, does May 11th work for you? Because I wasn't aware that you would have to travel.
I'm going to have to miss work and try to see what I can do about that. I wasn't even trying to collect attorney fees, Your Honor, because I'm trying to be reasonable. I just want him out of the house, Your Honor.
I understand.
And I understand that, Judge, and that, I felt the same way with with regarding Suzanne's surgery. I didn't expect the court to be, JP court to deny it on those grounds. And I was very specific. I even listed the surgery.
So I understand, but my contested hearings, I do have them in person. So this was actually set before we changed our schedule. If not, we would have changed you to a Wednesday so that you could have come in person. So just May 11th, 2 p.m. Because I don't know if you're familiar with our courthouse, but it's on the 3rd floor and it's County Court 4 courtroom. I don't have a courtroom right now. We're in court. So Judge Garza has been very kind in allowing me to use his courtroom. Okay.
Judge, and as an officer of the court, what I'll do, I'll speak to the Arces, the brothers, plural, to speak with their brother, Mr. Arce's father, and letting them know that this is to try to handle this within the family.
Well, they have a choice.
Yes.
I think Mr. Arce has just made it very clear that he just wants him to go ahead and move out.
Yes,
so that he
that's
can,
if I may clarify, this has nothing to do with my father. It is my house, Mr. Palacios. So you can contact me if you need anything regarding that.
I think what he was trying to say is just that, to see if it could be handled that way, but I think we're unfortunately past that.
Yes, Your Honor.
And so since Mr. Arce is the litigant and representing himself, it would only be, no one else would have the authority anyway to make any agreement. So I understand what you're trying to do, but I think it's past the family matter.
Exactly.
So I think really, quite honestly, Mr. Palacios, is that your client, Mr. Arce, has to come to terms with the fact that he is going to have to move out. So I think I'm making it very clear as to what the path is that I'm going to have to take, because that's the law. I don't have a choice. I'm following what's in the record of the JP court that was given to me, and I'm following the law down the line, which would be that if nothing has been proven in the lower court that Mr. Arce is not the rightful owner, as a rightful owner, he is not going to be forced to have somebody in that home that he doesn't want, and he cannot be forced to contract with anyone that he doesn't want to contract with. So I am sure that your client is going to have a difficult time accepting that, but he also needs his day in court, and Mr. Arce, as the plaintiff, needs his day in court. So we're going to all come back on May the 11th at 2 p.m. and we can either you all settle it before then, or we'll settle it on that date.
Yes, Your Honor.
Okay.
Thank you, Your Honor.
Thank you.
Maybe excuse.
All right.
Judge, we have nothing
Yes.
further. Maybe excused.
You certainly
Thank you.
may. Y'all take care.
Thank you.
Okay, Alicia Cárdenas.
Judge, she's not able to make it.
Alicia Cárdenas is on the screen.
Ana Alicia?
Alicia Cárdenas. I don't know. Is that her?
Yes, that's my wife. She's not gonna be able to make it today.
No, but she's on the screen.
Oh,
I'm here, Your
really?
Honor.
Okay, so Miss Cárdenas,
Oh, that's
you're married to Eduardo Cárdenas?
No, I'm
No,
Alicia
no,
Cárdenas.
that's not. Yeah, that's not my wife.
Okay, so it just happens to be, okay. Let me see. Miss Alicia Cárdenas, what case do you have?
It's a case number CL 143693I. It's National College Student Loan versus
yes.
Victoria Guerra Alicia Cárdenas.
Okay, that's number 3 on the court's docket, National Collegiate Student Loan versus Victoria Guerra and Alicia Cárdenas. Anybody here for National Collegiate Student Loan? National Collegiate Student Loan? National Collegiate Student Loan? Okay, therefore nobody's here, so I'm going to I'm dismissing it for want of prosecution. So I'm going to dismiss the case.
Okay, Your Honor, and but I need to do nothing else?
Nothing. You're going to receive an order. Do we have your email address?
Yes, you have.
Okay, then you'll receive an order to that saying that, okay?
Okay, thank you so much.
Thank you.
Have
a good day.
You too.
Okay, Eduardo Cárdenas Jr., that's F4020-19-9, in the matter of the marriage of Ana Cárdenas and Eduardo Cárdenas Jr. You said that she was not going to be able to make it, correct?
Correct.
Okay. And you all still wanted the divorce on file?
Yes, ma'am.
Okay, since your wife, Ana, is the one that filed, she has to be present because you don't have anything on file saying that you are doing a counter petition.
Right.
So do you know when she's going to be available to get on the screen?
I do not. Let me see if I can get in contact with her. See if we can.
Okay. Because I do have a divorce decree that you all filed back in January.
Yes.
But I don't know if that decree is the one that you all want. But since you guys have 3 kids together, right?
Correct.
Okay. So I can't do it unless she gets on also. So either you can contact her and ask her if she's going to be able to get on, or I can reset you for May the 16th.
No, we would like this divorce. Let me see if I can get in contact with.
Okay, well, you don't have much time, okay?
Sure.
All right. Clarita Chavarria, what case?
Hi, yes, ma'am. F dash 0308-229, and we're number 15, I believe, on your docket.
Okay, that's in the matter of the marriage of Clarita Chavarria and David Loya. Is Mr. Loya present?
I am, Your Honor.
Okay, let me go ahead and look up your case. Okay, so Ms. Chavarria, you and Mr. Loya do not have any children together, is that correct?
Correct, Your Honor, we don't.
Okay. And you all have entered into an agreement. As I see, the decree has been signed by both of you, is that correct?
Correct, Your Honor.
Okay.
Correct.
All right, let me go ahead and swear both of you in. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Chavarria, yes or no?
Yes, ma'am.
And Mr. Loya, yes or no?
Yes, Your Honor.
Okay, before we proceed, are you Mr. Loya or Mr. Loya Cruz or Mr. Cruz?
Loya Cruz.
Okay. Okay, let me go ahead and start with Ms. Chavarria. Ms. Chavarria, you are the petitioner in this divorce, is that correct?
Correct, Your Honor.
And you are currently married to Mr. David Loya Cruz, is that correct?
Correct.
And you were married on or about February 9, 2019 and ceased to live together as husband and wife in July of 2021, is that correct?
Correct, ma'am.
And you are asking for a divorce today because your marriage has become insupportable because of discord or conflict of personalities between yourself and your husband that destroys the legitimate ends of the marriage, is that correct?
That's correct, Your Honor.
Is there any chance of reconciliation?
No, Your Honor.
And no child was born or adopted in the marriage, is that correct?
Correct, Your Honor.
And you are not expecting a child, is that correct?
Correct, Your Honor.
Okay. And you and your husband have entered into an agreement with respect to your divorce, is that correct?
Correct, Your Honor.
Okay. So you are stating that, okay, so the property at 210 South Lackland Street in Ed Couch, was that purchased while you and Mr. Loya Cruz were married?
Yes, Your Honor. We're
Okay.
separated at the time, but yes.
Okay, and so you all have agreed that you will be retaining that property, is that correct?
Correct, Your Honor.
And that with all the furniture, furnishings, and fixtures, and your clothing, jewelry, and personal effects, correct?
Correct, Your Honor.
And any bank accounts that are solely under your name and any vehicle that you have in your possession, correct?
Correct, Your Honor.
Mr. Loya Cruz will keep all his personal effects, clothing, jewelry, any household furniture that he has in his possession, any bank accounts that are solely under his name, and any motor vehicle that's under his name, correct?
Correct, Your Honor.
And you will be responsible for any debts that you incurred solely by you after July 1st, 2021. Is that correct?
Yes, correct, Your Honor.
And Mr. Loya Cruz will also be responsible for any debts he incurred after July 1st, 2021, correct?
Correct.
Okay. And you are not requesting a name change at this time?
Correct, Your Honor.
All right. So Mr. Loya Cruz did sign the divorce decree that was filed with the court back in April. Is that correct?
Correct, Your Honor.
Okay. All right, Mr. Loya Cruz, you've heard the testimony by Ms. Chavarria, correct?
That is correct.
And is that your agreement with Ms. Chavarria as she has stated on the record?
Yes, it is, Your Honor.
And you are asking the court to accept the agreement?
Yes.
Okay, and do you acknowledge that you signed that final decree of divorce that has been on file with the court since April?
Yes, I do, Your Honor.
Okay, so then Ms. Chavarria, you're asking for a divorce today?
Correct, Your Honor.
Okay, so the court is granting a divorce, taking judicial notice of all the documents in the court's file. And I will ask that the decree of divorce that was filed on April the 21st, 2022 be forwarded to my queue for signature. And once that's signed, you all will receive a copy and your divorce becomes final 30 days after I sign it. Okay?
Okay, thank you, Your Honor.
All right. So anything else?
No,
Okay.
Your Honor.
All right. Wishing you all the best to both of you.
Thank you.
Okay, y'all take care.
Thank you.
Okay. Yvette Loredo. Yvette Loredo. Okay, Ms. Loredo, have you had contact with Felix Alonso?
No, ma'am.
Okay, do you know if he was gonna appear today?
No, ma'am.
Okay, the reason that we set you on the drop docket is because no one had been appearing on this case. So.
Correct.
All right, so are you still moving forward with the divorce?
Yes, ma'am.
All right. So what I'm going to need is, do you have an attorney now?
No, ma'am.
Okay. Does Mr. Alonso still live at 809 West Elbert in Far?
I have no idea. I know that was his last known address.
Judge, is that Mr. Felix Alonso on the line? Is that the correct one?
Oh, there he is. Okay, Mr. Alonso. Can you unmute yourself?
All right.
Okay, so Mr. Alonso, you are aware that Ms. Loredo has filed for divorce, correct?
Yes.
Okay. The only thing is that, let me see. And are you in agreement with this divorce?
Yes.
Okay. And you and Ms. Alonso do not have any children together, is that correct?
No.
And do you all have any property together?
No.
Ms. Loredo, do you all have any property together?
No, ma'am.
Okay. And what about any vehicles? Do you have anything under your names that you all, any
ma'am.
debt?
No.
No.
Okay, so this is what we're gonna do, because you don't have any children, you don't have any debt, and you don't have any community property. I'm gonna go ahead and swear both of you all in so that you can do the divorce today, okay? But
Okay.
you will need to have a final decree of divorce, and Mr. Alonso will need to sign it. Okay? Unless that's difficult. Do y'all don't talk then? Okay,
No.
never mind. I'm gonna go ahead and have both of you testify. I'm gonna make sure that we have a clear record. But Ms. Loredo, since you are the one that filed for divorce, you will need to submit a divorce decree. Okay?
That's fine.
And just sign it, and then I'll sign it.
That's
Okay?
fine.
All right, let me go ahead and have both of you all raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Ms. Loredo, yes or no?
Yes.
And Mr. Alonso, yes or no?
Yes.
All right, you may lower your hands. Okay, Ms. Loredo, you are the one that filed for divorce in this case, is that correct?
Correct.
And you are currently married to Felix R. Alonso, is that correct?
Correct.
And at the time that you filed for divorce, you lived in Texas for 6 months and Hidalgo County for 90 days, is that correct?
I'm sorry. Since I filed for divorce?
Yes, when you filed for divorce, had you lived in Texas for 6 months?
Yes.
And Hidalgo County for 90 days?
Correct.
Okay. And you were married on or about December 28, 2012, and you stopped living together as husband and wife on January 7, 2018. Is that correct?
Correct.
And you're asking for a divorce because your marriage has become insupportable because of discord or conflict of personalities between yourself and your husband that destroys the legitimate ends of the marriage. Is that correct?
Correct.
Is there any chance of reconciliation?
No.
And no children were born or adopted of the marriage, correct?
Correct.
And you are not currently expecting a child?
Correct.
And you and your husband do not have any community property that you acquired during the marriage, is that correct?
Correct.
And you and your husband do not have any debts that you acquired together during the marriage, is that correct?
Correct.
So you will be responsible for any debts that are solely under your name that you incurred from the date of marriage, is that correct?
Correct.
And Mr. Alonso would be responsible for any debts that he incurred under his name and solely by him from the date of marriage, is that correct? He would be responsible for his own debts.
Correct.
All right. Okay, and you are not requiring a name change, is that correct?
Correct.
All right. Okay, Mr. Alonso, you've heard the testimony of Ms. Loredo. Is that your understanding as well?
Yes.
Okay. And you understand that you'll be responsible for any debts that were solely incurred by you under your name from the date of marriage?
Yes.
Okay. So now what I'm going to take judicial notice of all the documents in the court's file, and I'm going to grant your divorce. So, but you will not be legally divorced until 30 days after I sign that divorce decree. All we did was take care of the formality of the testimony. So Ms. Loredo, I need for you to get that divorce decree on file as soon as possible. Okay? And I'm going to give you until May 20th to get that in. If you do not get that in by May 20th, then I'm going to have you come back and appear as to why it hasn't been done. Okay? All right. So you all already did the testimony, and now I just need that decree. Okay?
All right. Thank you.
All right. If nothing further, you may be excused.
All right.
Thank you. All right. Ms. Galvan, are you there?
Judge, I don't mean to interrupt. I'm sorry. My wife requested the rescheduling.
Okay. Did she say on what date she'll be able to appear?
No, any day other than today. It was just a circumstance that we had to get through.
Okay, May 16th
May 16th. Okay.
at 9:30.
Okay. Thank you, Judge.
Okay, thank you. Okay, Ms. Galvan, can you hear me? Ms. Galvan? Okay, Mr. Alvarez, can you hear me, Mr. Alvarez? Attorney Juan Alvarez.
Sorry, Your Honor, I'm right here.
Okay, good morning, Ms. Canales. All right,
morning.
are you here on Raul Gonzalez?
Yes, I am.
Okay, CL 143510-I, Raul Gonzalez versus 3911 International. And did you want to retain this case on the docket?
Yes, I do, Your Honor.
Okay, because it said for a DWAP.
Yes, Judge.
Okay, so what, did you want a status hearing? Or
Yes, Your Honor.
how can we proceed with it?
A status would be fine.
Okay, have they already been served?
Yes, they have.
Okay, did they file an answer?
I don't recall, Your Honor. There's a opposing counsel on the screen, correct?
No.
Oh, okay.
Mr. Velasquez is here on another case.
Oh, okay. I'm sorry, Judge. I thought that was opposing counsel. Then in that case, Your Honor, they have been served, Judge, but this case is very old. It was a bar fight. And apparently the bar has gone out of business. And they have no money. So if you can just retain it on the docket, I did speak with my client and he was understanding that it might get dismissed, but I'm gonna give it one more try, Your Honor, to see if I can do anything with this case. If you can just give me like maybe a 60-day status, if that's okay.
Okay. Yeah, I'm looking and I know that they counsel for them withdrew. I don't think they obtained new counsel and nobody is showing up on their behalf, but we'll do a status on June 27th at 9:30 and you can let me know at that time whether or not
Okay,
will occur.
we'll do that. Thank you,
Okay.
Judge.
Thank you.
Thank you. Bye-bye.
Okay. All right. So, Mr. Velasquez, are you here on Capital One versus Ida EIRA Jimenez?
Yes, Your Honor.
Okay, so I do see that Ms. Jimenez is present. That's CL 191630-I. Have you all had an opportunity to talk or?
We have not, Judge. As always, I'm always happy to speak to Ms. Ira if she would like a chance to talk and see if we can work some out before trial.
Ms. Jimenez, can you please unmute yourself?
There. Can you hear me? Sorry,
Yes.
I don't know how to.
Okay, Ms. Jimenez, I'm going to give you an opportunity to talk to Mr. Velasquez's office to see if there's anything that can be done. Did you want to try to work this out?
Yes, because I myself never took out a card from Capital One. I've been receiving paperwork and everything, but I never took out anything, a card from the credit card.
Okay, do you have something to write with?
Yes. Go ahead.
Okay, Mr. Velasquez, can you please give Ms. Jimenez contact information where she can talk to you all about this?
Yes, Your Honor. Ms. Jimenez, the number you can call to try to see if you can work it out is 262 796 7890. Your file number that you want to reference is 361 6631.
Okay.
And Your Honor, there are deemed admissions in this case, but before we even get into that, I'm happy to give Ms. Jimenez an opportunity to see if things can get worked out.
Okay. All right. So then I'll go ahead and give you an opportunity. I'm going to set you for a status hearing for June 27th at 9:30. If it's worked out before then, we'll go ahead and see that. Ms. Jimenez, just a side note, this is a court of law. In the future, I do not allow tank tops or anything like that. You need to be dressed appropriately for court. Okay? So
Right,
June
sorry.
27th at 9:30.
Your Honor, and just for clarification, I know some courts have moved to in-person. Is this going to be in-person in June, or would this be Zoom?
Zoom.
Okay, Judge.
Go ahead, Ms. Rivera.
Judge, may I have her email, please?
Ms. Jimenez, can you please put your email address on the record?
YAYA85871 @gmail.com.
Okay. All right. Then I'll give you an opportunity to contact them and then we'll see you back here on June 27th at 9:30, ma'am.
Okay, ma'am. Thank you very much.
Yes, ma'am. Thank you. Mr. Velasquez, anything else?
Nothing further, Judge. Permission to be excused.
Yes, sir.
Have a great day, Judge. Bye-bye.
Likewise. Okay, Ms. Galvan, CL 200050-I, Norma Richmond versus Elgin's ELGINZ Investments.
Yes, Your Honor. Monica Galvan for Norma Richmond. I have not.
I'm sorry.
On the.
I can't hear you. You froze.
Okay, I'm sorry, Your Honor. I'm in the courthouse. I haven't seen the defense attorney on the screen, but I'm asking for the court to continue this case on the docket. We're going to file a motion for DCC today so that we can get it moving.
Okay. go ahead and file a motion for DCC, and then I'll go ahead and retain it on the docket.
I appreciate it, Judge. Have a nice day.
Okay, likewise.
Thank you.
Okay, I'm gonna call CL 191451-I TD Auto Finance versus Erica, ERICKA Martin et al. Erica Martin, Eddie Martin III, Eddie Martin III, Eddie Martin III, TD Auto Finance, TD Auto Finance. Okay, no response from plaintiff nor defendant. This will be dismissed for want of prosecution. CL 220623-I Feliciano Jesus Shine, CHEIN versus Connie Cobb as substitute trustee. Feliciano Shine, Connie Cobb, Connie Cobb, Connie Cobb. No response from plaintiff or defendant. This will be dismissed for want of prosecution. Number 19, CL 214696-I McAllen Nursing Center versus Henry Leo. Did anybody call in on that?
No, Judge.
Okay, go ahead and set that for the drop docket. And that concludes this morning's docket. Let me stop.